Mr. Agbaje, we will come to, if it was left to you and you were the judge, we will come into how you would have maneuvered the prayers to come to that particular conclusion. But I don't know if I have the right copy of the Constitution here. I'm looking at 306, Section 5, subsection 5. It says, the notice of resignation of the governor and of the deputy governor of a state shall respectively be addressed to, the Speaker of the House of Assembly and the governor of the state. So it is more specific.
Yes.
Oh, yes. It is more, for the deputy governor, it would seem that it is very specific.
As to the governor.
As to the governor.
Marco, where was the governor? Yeah, the letter has to be written. This is the governor's letter. You see, this is the, as far as I'm concerned, this is one of the constitutional incongruity in what we are practicing today. This is my letter of resignation addressed to the governor. The same governor the House of Assembly cannot find. Where am I going to find him?
No, but we know that in court. I mean, in some cases, what's the principle of, what do you call it, substitute service?
Right, exactly.
What's the principle?
Did you do it?
No, but there's a principle. That principle is established to take care of this kind of situation. So if he was not found, if he was nowhere to be found, and then they wanted to properly follow the process or strictly follow the process of removal, wouldn't they have thought about that process?
That is the thing. It was not thought of.
So can we then assume that because they were blinded by their
ambition
and then they couldn't see the fine line? Because
let me help you further, Timberlake. Do you know, under the impeachment preceding provisions of the Constitution, the House or the Houses of Assembly are enjoined to make rules to govern impeachment proceedings? But I want to tell you categorically today that 90% of the House of Assembly we have today in Nigeria don't have rules to govern impeachment proceedings. But all they are interested because they see it more as a political issue, not a constitutional matter. Whoa, this governor, whether you like it or not, you are going. We will remove you. That is why it was easy for some people to even go to hotels and restaurants to go and impeach a governor. But thank God there is sanity in the system now. They will now sit in the House chamber and still decide on your fate, irrespective of what that law says. Any of them because under that section of the law, they are supposed to have made rules for situations like this. So in the case the governor disappears, vamoose. How do we trap him?
I was going to ask you exactly. I mean, that loophole. I mean, if ever it came up that, say, for instance, a governor, for whatever reason, is not, available. Say, for instance, he dies, and then his deputy is not willing to step into his shoes and wishes to resign. At that point, who does he tender his letter of resignation to?
That is the constitutional lacuna that have been created under the present constitution. If he dies, if the governor dies in office, and the deputy governor says, look, I don't want to inherit somebody's, I don't want to be sworn in. But can he actually say so?
I mean, if for instance...
Will it not amount to he eating his cake and having it, appropriating and reprobating? If you have allowed yourself to be sworn in as the deputy governor, and the governor dies, or the existing governor falls from an aircraft and cannot operate, you are supposed to move in and then or act until when he can recuperate. Now the man is not coming back, or evidence abound that the man is not coming back. You have been promoted now to go and take his position. You say, no, I don't want it. I want to remain as the deputy governor.
You don't even want
so he cannot.
Or you don't even want to be deputy governor at all. You don't want to be acting governor. You don't want to be deputy governor. Does the Constitution envisage such a situation?
It doesn't. I think what should be best for such a person is, look, if you don't want to be promoted, when you are not a storekeeper in a company who will be promoted, the GM, and said, look, I didn't ask to be promoted. I want to remain as a storekeeper here. He's a thief. He doesn't want to leave because he's been enjoying certain things there. Otherwise, he should resign. He should resign.
I'm asking this question.
Your hypothetical question is quite realistic.
Exactly. I'm not imputing any motive to it. I mean, maybe because for whatever reason, whatever circumstance, whatever personal reasons to that particular deputy governor at that time. What would any legal practitioner advise that deputy governor to do?
I would have advised him.
Considering the lacuna, this is a hypothetical situation, not, the Adamawa matter.
Yes, I would have advised him that since you don't want to move front and you want to remain where you are.
You don't even want to remain where you are. You want to resign totally.
Then you have to resign.
If you resign, then we call on the speaker.
to move to
who is the question? To the governor that is dead, or to the speaker?
In a situation like that?
Yes.
Of course, the governor is dead, and the next man says, I don't want to move there.
Yes.
So you can direct it to the Speaker of the House, and that is where the Constitution does not allow that. The present Constitution does not envisage such a scenario. And this is what the Adamawa case is an eye-opener. We must begin to look inward. How do we amend this militarily imposed Constitution that have created so much of lacuna that will enable somebody to benefit from his deliberately created wrong? That is my point here. You should not benefit from it, whether as the Speaker or as the Deputy Governor. I'm totally against it.
Let me bring in.
I wanted to bring in another argument because I'm so excited about this law and morality. Perhaps, definitely you know John Gardner, a professor of jurisprudence in Oxford. He's been writing extensively on this particular one, and I've tried to look at it. He says in his book, in his writings, Law and Morality, he says not all law has aims. And he went further to also talk about so many other issues. He said, yet all legal officials, even in such a system, must at least pretend to have moral aims when they act in their official capacities. Pretend. So, or, as it is often put, they must at least make moral claims on behalf of law. So, in this case, this lawyer has pretended to be what you wanted him to be because there was a crisis. No one for him to hand over his resignation to. Perhaps, maybe that section of our Constitution was actually put there with no aim or no intention.
Yes.
Which sometimes in some constitution, it is the case.
Deliberately
good. So in this case, do we blame him for actually trying to pretend, if that is what he finally did, to have a moral...
And then turn around to claim the benefit of that situation he has created.
The system created it.
You cannot eat your cake and have it.
Because the system created it.
This argument on morality and law, although most people will just jump and say, well, law has nothing to do with moral. It's rather unfortunate. You see, when you look at, I want to tell you today, do you know why most electoral petition cases fail in court? Despite all the gamut of argument here and there that election have been rigged, and the tribunal gives verdict and said, look, we uphold the election. What the tribunal is simply saying is that once you cannot establish that those violations actually affected the ultimate result of the election, what the tribunal will hold at the end of it is that there have been substantial compliance with the electoral. Substantial compliance. What substantial compliance simply means that they are not bound to comply everything in that law. But that is it. That concept of substantiality of compliance is not a new innovation. It is an offshoot of the natural law school. And when you're talking about natural law school, you're talking about morals. And that's why nations today are being judged on their human rights record. Not treat positive approach that lack human touch. You must be able, like you rightly read out, even when you read the lives of Professor Fuller, they will tell you that some judges will tell you think I'm sitting here as a robot? You want me to just apply the letters of the law? They will ask you, what are the spirit?
Just quickly, sorry, Chamberlain, let's quickly now come to, if you were the judge, you've said that both of them, neither of them, will smell that office of governor.
There are the cases where cases have been thrown and say, well, you that is before me.
Yes.
You have participated in the commission of the crime you are alleging.
The question
why do you think you can use the instrumentality of the law to get justice? You can't use, law must not aid fraud. That's the basic principle. Law must never aid fraud.
Wouldn't you then be descending into the arena? Because, I mean, as you rightly, you say that the FEE is not blind. That's what you say. But it
if the High Court does not see it, the Appellate Court will see it. That's the essence of that FEG. If the Appellate Court does not see it, the Supreme Court will see it. That's why I don't believe that justice is blind. It's not.
I think that is also debatable. For all best reasons, they present it to us as blind, but it's holding a scale, which means that there are supposed to be arguments for and against a particular particular matter before it. Now, if you're to reach the conclusion you're going to be reaching, how are you supposed to reach that particular conclusion?
Let me tell you this. First and foremost, the facts have been presented, or the fact comes to you, you know what has been presented, it does not tally with what you know is happening. You have the right to write to the CJ back, take this file, assign it to somebody else.